everybody. Welcome back to Psychedelics Today. Today we are joined by Kathryn Tucker, Special Counsel at Emerge Law Group in Oregon. How are you doing today, Kathryn?
I am well, thank you. Thanks for having me on.
Yeah, I'm excited. Been really impressed with your work I think I've been familiar with you for a little over 2 years now, and the kind of work you're doing is really impressive. I
Oh,
think
thanks.
what first came up was your end of life advocacy. Um, could you talk a little bit about what you did there in Oregon specifically, and then we can maybe talk a little bit more about the federal stuff?
Yeah, well, so my career has been for 35 years in advocacy to protect and expand the rights of terminally ill patients. And across that now long span, that's involved a lot of different things. I first came into the space in 1990 as campaign counsel to the nation's first initiative petition to enact a death with dignity law. And that was in Washington state. And it came within shouting distance of passing, but did not pass. However, it was the stepping stone to successful enactment of a similar measure in Oregon in 1994. And that work really took me into this arena of the interface of law and medicine at the end of life. And I found it extremely interesting and stayed there for the next 35 years and continued to do a lot of different work around expanding choices at the end of life to include what some people call death with dignity, but which is more often now referred to as aid in dying, and was involved in many initiative campaigns and also legislative efforts around the country to enact those laws, but also did a lot around how do we improve pain and symptom management and how can we galvanize changes in law and policy that will lead to better pain and symptom management, to patients being able to make a broader range of choices and have those choices respected. And then, more recently, probably 5 years ago, I became really keenly interested in the work with psilocybin for relief of anxiety and depression in patients with advanced illness, and started reading the studies coming out and finding that the relief was so enormous that I wanted to become involved in advocacy to open access to psilocybin therapy in particular for that population, and started doing work in that domain.
Awesome. That's really cool. So, what does that process look like for a non-attorney? Did you have to kind of start an advocacy group, or how did you go about it?
Yeah, so when I was um, beginning my advocacy in this arena, I was with a large law firm and eventually stepped across into the nonprofit sector. And most all of my career has been spent in different nonprofits as director of legal affairs or director of advocacy, and sometimes executive director. Um, when I more recently stepped back into private sector as special counsel at Emerge, it was to help that firm launch and grow a psychedelic practice. And so I'm back in the private sector, and my work is focused now in opening access to psychedelic substances and has included things like work on the Oregon Psilocybin Services Act campaign, which, as you know, was successful in 2020 as the nation's first state legalization for access to psilocybin. And I now continue to work on campaigns that are somewhat similar around the country, and maybe we'll have time to talk about some of those. But I also had launched the work to open access to patients with advanced illness to psilocybin as an investigational drug under state and federal right to try laws. And that work is really exciting because if successful, it will create both state and federal safe harbor for access to that drug. Whereas, of course, what can happen when a state legalizes, only a state safe harbor is created.
Hmm. Right. And there's plenty of people out there having a really tough go at it that could really benefit from these types of services and treatments.
Yes. Well, when we were speculating on the success that was somewhat surprising in Oregon in 2020 because it was the first statewide initiative to make psilocybin legal and accessible. So it seemed like a difficult task, and it was embarked into during the pandemic when signature gathering was difficult because people really weren't supposed to gather. Um, the success, though, seemed to be in part because of the growing recognition that mental health challenge is pervasive and the tools that exist are inadequate, and that this is a new tool to address a variety of mental health challenges. So I do think that burgeoning awareness is lifting this movement forward.
Do you So you've interacted likely with far more politicians than I have on this topic. Like, what's the general conversation go like when you try to talk about this for end of life specifically?
Well, I mean, I think that the pushback sometimes is in the general war on drugs, just say no to drugs mentality. I think that sometimes it relates to the fact that many of these substances are still in the investigational stage, and the interest in seeing the full FDA review and approval process wend its way to completion. Um, that process, while I very much respect those intrepid researchers like Roland Griffiths at Johns Hopkins and his next generation of researchers, including Matthew Johnson, um, their work is so important, and yet it is a slow process. And so, for people with terminal illness that is progressive and advancing who don't have time to wait for that long, slow process to wend its way to completion, I think we do need to make use of laws such as the state and federal right to try laws that recognize exactly that and say, well, for patients in that population, as long as the investigational drug has successfully completed a phase 1 clinical trial, that drug should be available because these patients can't wait. And I had such a moving email exchange with one of my cancer patient clients in the litigation about opening access under right to try, where she just concluded the message saying, I'm running out of time.
Hmm.
So there's a real urgency. And, part of what's been so frustrating, of course, is when we satisfied ourselves as attorneys that the state and federal right to try laws did, in fact, apply to psilocybin and that it should be accessible for therapeutic use with patients with advanced illness. When we approached the DEA to inquire how it would enable that access. Um, that inquiry was in January of last year, 2021. So we're now more than a year later, and the DEA is still obstructing access. And the frustration of that for me with regard to the clients that I represent who have advancing cancer is just really heartbreaking. Um, so we did take the DEA into federal court. What the agency argued is that it hadn't, in fact, given us a final agency answer. And the court agreed with that. And so basically, nothing happened for that year, other than I hope the DEA did get itself a deeper and better understanding of its requirement and obligation under right to try. But we still haven't been granted access. So when the court said, well, you really need to get the agency to give you a more final answer before we can take judicial review, we went right back to the agency days later with a very explicit request: give us your final answer so that either you open a path to access and these patients will get relief, or you deny that access in a way that opens judicial review. But that letter has now been sitting at the agency for nearly a month. And, another really challenging piece of this is, where are the voices of federal elected officials? Where is the voice of Senator Patty Murray, who is the senator for my clients who are based in the Seattle area? She's on the health committee. She's a long tenured senator. Where is her voice calling out for the DEA to respect duly enacted, and I should point out, with wide bipartisan support, which is rare in this day and age? Why isn't she calling out for that duly enacted law to be respected, and that this agency, which has a very specific authorization and scope of authority to police against diversion, why isn't she calling for it to stay in that lane and not obstruct access to a therapeutic medicine for treatment of suffering and dying patients? We need to hear those voices.
Yeah. Um, I've got a lot of things I could say about the DEA, but I'll keep it inside for now. So, what are the mechanics of this? Or is there like because I recall many moons ago when this got passed, the Federal Right to Try Act, there were people saying, "Oh, now I have permission to go ahead and do this with anything that's passed a phase one clinical trial." But it sounds like that's not actually true based on what your experience is. Can you, like, what, just to get started, say you've run out of options, do I need to then go hire an attorney?
Well,
To,
so that's such a great question. What the statutes call for is that the eligible patient and their physician uh, discuss the potential risks and benefits of the investigational drug. And if they conclude that this, in fact, is something that the patient wants to try, then there is a call for a very elaborate informed consent, because, of course, we're talking about an investigational drug. And so, less is known about it than a fully approved drug, although question mark if that's true with regard to psilocybin, which has been around and quite known for so long. But in any
yeah,
event, when that informed consent is completed, then the physician would take the informed consent and go to a potential supplier, a manufacturer of psilocybin, and request that that drug be dispensed to that physician for therapeutic use with that patient. That is sort of the basic framework of how RTT should work. Because there's a Schedule 1 substance involved here, um, no supplier would transmit the drug to the physician without some form of approval from the DEA. So that form of approval could be various things. The DEA has many tools in its toolbox. It could issue a waiver from registration requirement, so that, normally when the physician goes to the manufacturer says, "Sure, I manufacture this drug. I can transmit it to you if you show me your DEA registration that qualifies for this schedule." The DEA could waive that with regard to an RTT compliant psilocybin. It could also choose to issue an exemption or an exception. So these are different ways that the DEA could make access possible. Um, we haven't felt that it was our place to tell the DEA which tool to take out of the toolbox. Our position more is, we recognize you have many tools. Make use of the one that you determine is the appropriate one that would open this access. So as soon as the DEA chooses to use a tool to allow access, then it would open the door for the flow of this medicine to this physician for treatment of this patient.
How can psilocybin containing mushrooms work in any way here?
No.
Since
So
you
that's
wouldn't have to go to a supplier.
Yeah, that's such a great question. So, if you understand the particulars of the right to try law,
Hmm.
the right to try contemplates access to an investigational drug for which an investigational new drug application is on file with the FDA, and that has completed a successful phase 1 clinical trial. In the US, the psilocybin that fits that set of requirements is synthetic psilocybin.
Hmm.
So it is not the fungal. One of the really interesting things is that USONA Institute has been uh, supplying psilocybin for clinical trials in the US. And so USONA could be a supplier. USONA is very laser focused on completing the rest of the clinical trials and the new drug approval process. I don't know that it would be willing. We've had some discussions. If the DEA opens a pathway, I would hope it would be a willing supplier. But one of the interesting things about USONA is it has put its synthesis process into the public domain, very much to its credit, as opposed to some players in this space that have been busily attempting to patent and secure patents on all kinds of things related to psychedelic therapy and medicine. USONA's put this in the public domain. So any GMP lab could take the USONA synthesis process and create identical psilocybin that is the subject of the USONA IND for psilocybin.
So I guess for clarity, by some perceptions, multiple forms of psilocybin are being investigated at the federal level, right? I don't. I kind of am dubious of those differentiations, but um, either, let's get explicit. So like Compass or Usona psilocybin, theoretically different according to patent applications. Those would both qualify if the DEA made a pathway for them.
Yes, but what has not yet become RTT eligible is fungal
Hmm.
psilocybin, the psilocybin that grows in the psilocybe mushroom. Now, I am aware that there are those who are really interested in seeing an IND submitted to the FDA, an investigational new drug application for psilocybin that is from the mushroom. And that work is ongoing. That will require the development of that investigational new drug application and then the conduct and completion of a phase 1 clinical trial before that would be RTT eligible.
Hmm. Interesting. Okay. And we all
But
know
that
that
may
a
not
whole,
be too
yes.
far away.
Oh, really?
Yeah.
Interesting. From my perspective, like plant and whole organism is a little bit too complex for regulators to handle. But I'm optimistic by your statement there. Can you give us a little more there?
Well, I know of colleagues in the research world who are busily attempting to raise the necessary funding to prepare that fungal IND for psilocybin and then to create and conduct at least this phase 1 clinical trial. And that fundraising effort is ongoing. And of course, many in your audience may be philanthropists in this arena. And so there's certainly a need for funding to come in for that purpose. And that would be really exciting to see. So any funders out there that want to see that happen, please be in touch, and I'd be happy to connect you with the researchers that are looking to do that work.
And if Kathryn, if they want media, send them my way. I'm happy to help get them attention and
Beautiful.
hopefully, as a result, money.
Yes.
Yeah, because that would be
Yeah,
beautiful, right?
sometimes it's just letting the philanthropy world know of the need and the opportunity.
Hmm. Exactly. Beautiful. So, yeah, the right to try thing is really interesting. So, earlier you mentioned one of your clients saying my time's running out, something along those lines. And what came to mind for me was people with not necessarily cancers or terminal diagnosis, but maybe a different kind of terminal diagnosis, like intractable suicidality, for instance, or just
Yeah,
very aggressive PTSD that could go off the rails at any moment, right? And
yeah. Yeah, you're
um,
so right. And I'll mention, in case you haven't read all of the briefing in the Ames case, which, by the way, for you and any of your audience that wants to take a deep dive into understanding the law of right to try as it pertains to psilocybin, I have posted all of the briefing on the Emerge Law Group blog, where I have blogged about the case as it has gone along and embedded the underlying briefs that have been filed in federal court, all of which are public record. But in one of the briefs, and one of the really interesting briefs that was submitted to the court, as you may know, when important federal or state cases are in front of the courts, not only do the parties submit briefs, but there are briefs called friend of the court or amicus briefs. And in the case I've been handling, we had a very robust amicus participation by a wide variety of amici, including a cohort of states, which came in to say to the federal court, this action by the DEA to obstruct operation of right to try law is an impingement on our sovereignty. We as states have the sovereignty and the primary responsibility to determine the regulation of the practice of medicine. That's an area of law that's been
wow.
strongly litigated. I was actually involved in sort of the landmark case in that arena, which was when the Attorney General John Ashcroft and then his successor, Alberto Gonzalez, were trying to use the Controlled Substances Act to punish physicians in Oregon who participated under the Death with Dignity statute. We immediately challenged that act, and at every level of the federal courts, including the Supreme Court of the United States, the ruling was exactly that. It is states who have the primary responsibility for the regulation of the practice of medicine. So that's an important precedent in our RTT case, and it is what brought so many states to file that amicus brief. Now, I mention all of that because in that state brief submitted by 8 attorney generals of states across the country, they very specifically addressed what you alluded to, and that is also an eligible investigational drug is MDMA, which has successfully completed phase 1 clinical trial and which has been shown remarkably efficacious in relief of life threatening PTSD in veterans in particular. So the RTT statutes speak in terms of life threatening. And if a veteran is at risk of suicide, that is a life threatening condition. So if our case is successful, it should also open access for that population and for that eligible investigational drug.
Mm, that's important. Wow.
Yeah.
I love that. Um, so you're making me a little more angry than normal about the DEA. Um, what, like, have you seen the Tshirts? The DEA is a terrorist organization at all?
No. No.
Like all you have to do is a little bit of reading on the DEA's history, and it's not pretty, right?
Yeah.
And I was talking to some people in medicine the other day, and their DEA is not bad. They just control diversion. I'm like, well, good lord, at what cost? And like, you
Well, and
know,
yeah, and the thing here, again, to bring it back to reality, what we're talking about here with regard to right to try access is a physician who already holds a registration with the DEA. So this is someone who is known to them as a responsible professional who takes possession of controlled substances at his integrative oncology clinic in Seattle. He already is subject to DEA field visits to ensure that he has adequate security for possession of controlled substances. And then he uses those in treatment of dying cancer patients. The risk of diversion is minuscule here in that setting. And we have offered, of course, invited the DEA to undertake whatever field office investigation it feels appropriate of the Ames Institute to ensure itself about safety measures to prevent diversion. We would invite that. And that, of course, is the appropriate scope of DEA authority. But to absolutely prohibit access when state and federal law are intended to allow access, that is impermissible. So the T-shirt that I might propose, as opposed to the one you alluded to, is DEA, get out of the way.
hmm I like that.
And these dying patients could have immediate, substantial, and sustained relief from debilitating anxiety and depression. That's what all the studies show. And I'll say those words again because they're the words that really caught my attention: immediate, substantial, and sustained relief. And
hmm
why anyone would obstruct access to that kind of relief for a dying patient is impossible to comprehend. And I might also mention, of course, the reality in the state of Washington, where this physician and his clinic are. Washington is a state that does empower dying patients to choose to ingest controlled substances to advance the time of death through the practice of medical aid in dying. When you allow dying patients that option, surely you would want to offer them the option to elevate and expand consciousness, which is what psilocybin has been shown to do. And it might impact how those patients feel about advancing the time of death. We don't know. There's no data bearing on that yet, but we've seen leading physicians from the hospice and palliative care arena, including the past president of the American Academy of Hospice and Palliative Medicine, hypothesize that if dying patients had access to psychedelic assisted therapy, their interest in aid in dying might diminish or erode. That's a really interesting possibility. Again, data doesn't reflect on that yet, but surely we would want to offer this new palliative care tool to that population.
hmm That's super interesting. Like obviously with the um, death with dignity work, like there's a certain element of Christianity that's not liking that, and maybe that was something like Ashcroft's cover
Yeah.
in a way. If not, I don't know that they're well. I could see keeping somebody in a hospital being a lot more profitable. So maybe that's the angle. I don't know. You have to speculate because you don't really ever know. But on this DEA get out of the way approach, what's going on there? Like for, hmm,
Well, it's new.
hmm
I will give the agency the recognition that it had never before been approached about right to try access for a Schedule One substance. So when this first was presented, I could imagine that the DEA didn't know very much about right to try, and that it has a knee-jerk reaction that no Schedule One substances are to be accessible, except for research. But we've now spent a year with extensive legal analysis of what RTT calls for. And the agency has had, of course, DOJ attorneys representing it. They've had the chance to take a deep dive into the law. And to not bore your listeners too much, and maybe some of them are attorneys and they'll love this piece, I'm going to say this little very legalistic piece, which is the right to try federal law is an amendment of the Food, Drug, and Cosmetic Act, the FDCA. The FDCA is implemented by the FDA. So this is going to be an alphabet soup. The DEA implements the Controlled Substances Act, the CSA. There is a provision in the CSA which says nothing in the CSA is to take priority over the FDCA. So there's a federal statutory recognition that if there is a conflict between the FDCA and the CSA gives way to the FDCA. Well, RTT is embedded in the FDCA. So there's the answer for the very legalistic. And that, of course, is the issue that eventually it may be necessary for the federal courts to rule upon. Although I will say that with our renewed request to the DEA stands at a fork in the road. It can either take the fork to open access, and there's no need to return to federal court. Patients will get relief. Duly enacted law will be respected. Diversion controls can be put in place. Everybody wins. Or the DEA can choose the other path, which is to continue to obstruct, but do it in a way that's final enough that opens the courthouse door so that the court can look at that alphabet soup that I just described and make the determination. But let's have the DEA make a decision. This is the other thing that's maddening about the conduct of this agency on a big menu of maddening behaviors. Delay, slow walk it, just let it sit there and gather dust. While my clients are dying of cancer and are sending me a message saying, I'm running out of time. I recently did a podcast with the metastatic breast cancer community. And these are people who have been on the road with cancer for some time to the point where their cancer has now metastasized. And that's that population in cancer care that is really looking at the end of life. And they, of course, want to see access open for their community. And so, to all cancer activists out there, please join us in this effort. Please be writing to Senator Patty Murray and your federal elected officials, the whole panoply of federal electeds. We did see Representative Earl Blumenauer of Oregon, who's a very progressive and highly respected member of Congress. He led a bipartisan letter to the DEA when our case was pending, sent on January 18th. It was widely covered in the media, saying, of course, our constituents need access to this medicine. Open a pathway. So we have seen some courageous federal elected officials call on the DEA, but there should be an upswelling of this call, and there should be a bright light of public scrutiny shining on how the DEA is handling this request so that it can't sit on the back burner and it can't be ignored.
Mm. Right. I know they have a habit of that. I believe even with the Soul Quest application, they sat on that for quite a bit of time too. So it seems to be a habit and a tactic. I don't really understand it, but it seems to be what they've chosen to do, right?
Well, it's very effective in denying access. I'm not going to comment on SoulQuest, but what I will say is the population intended to be benefited by right to try laws um, is among the most compelling imaginable. These are
Mm,
people confronted with the reality that their life is coming to close. The client that I described to you, who's described for me that she's running out of time, she's a young mother. She has two children at home. She does not expect to see them to adulthood. She doesn't expect to see their next birthday. So the anxiety and depression that arises for someone who's been dealt that card, it's real. It doesn't have time to wait. It's urgent. And we should care about these people because that could be any one of us tomorrow.
hmm I was in a meeting not that long ago with David Bronner, and he was ready to just go protest at the DEA's headquarters
Well,
right
I'm
away.
ready now to call on David Bronner to do that. And I'm ready to, call on him to fund some beautiful tie-dye t-shirts that say DEA, get out of the way on all of those marchers. I do think with the litigation now concluded for the moment, right? So the court dismissed the case, finding no final agency action. There's a window of opportunity for public demonstration and federal congressional oversight that might not be open if the case was still pending, because sometimes what the agency or the federal elected will say, well, there's litigation pending, we can't comment. There's no litigation pending now. I would just as soon not need to return to court, although I think our merits arguments are incredibly strong. I'd much rather see the DEA just adopt an attitude of everyone can win here. Our interest in diversion protection can be addressed. The patient's need for relief can be permitted, and everyone can declare victory and go home.
Mm, right. It certainly would be a lot simpler and a lot cheaper, and probably a lot less embarrassing for the DEA once the story starts getting told more and more.
Yes, well, I really appreciate that recognition. And it's not even just embarrassment. The DEA cannot possibly want a federal court to decide in a precedent bearing opinion that the CSA is subservient to the FDCA. That issue has never been litigated. And agencies like to imagine that they hold broad power. For the DEA to be told by a federal court that its power is circumscribed because the FDCA has priority over the CSA, that would be a tough pill to swallow. So it's in the DEA's interest to avoid that teeing up for judicial review. But again, we can't wait here. And we're going to do everything we can to hold the DEA in the bright light of public scrutiny to take action. And if this seems to be languishing, which, from my client's perspective, it's already languishing. But if the DEA is dragging its heels here, we can go back to court with a mandamus action, which seeks to compel the court to compel the agency to act. And I think our facts here are that we don't have time to wait. We do have urgency. So we're going to give the agency a little bit more time to respond to our request. My phone could ring right after this interview, and it could be a DEA official calling to say that yes, a pathway will be opened. That would be great. But we're going to create the record that would support a mandamus if we need to pursue it. And we're going to invite activists everywhere, whether they're psychedelic activists, whether they're cancer activists, whether they're veteran activists, to shine the bright light of public scrutiny on how the agency is handling this. And I should say, when in the wake of the Ninth Circuit ruling sending this back to the agency, we not only requested a final agency determination. But we also filed a petition to reschedule psilocybin off of Schedule 1. So that's the first petition that I'm aware of that has ever sought that rescheduling with regard to that drug. There's every reason in the world for it to come off of Schedule 1. So we've given the agency another way to make access possible because, of course, we asked for it to come from Schedule 1 to Schedule 2, which remains a severely restricted schedule. We chose to ask for the smallest rescheduling step, even though many researchers, including those out of Johns Hopkins, have suggested it properly belongs on a much lower schedule. Because we wanted to make it easy for the DEA. So we've always been eager to satisfy any legitimate concerns the agency has, and we're eager to work with it to see a safe, diversion proof pathway opened to this medication that can bring immediate, substantial, and sustained relief to dying patients.
Mm, beautiful, beautiful. Um, so I feel like we've done a lot with the feds. Do you have much to say about Oregon?
Yes. So I was involved in the campaign to enact the Oregon Psilocybin Services Act. And I, in the wake of that, have convened a group that I've been really enjoying working with here in Oregon called the End of Life Interest Group. It's primarily comprised of clinicians who practice in the end of life care domain. So there are hospice and palliative care nurses, doctors, and mental health specialists. And we've been working to ensure that the interests of the population of patients with advanced illness will be adequately served under the Act. So that's been my primary ongoing involvement. Obviously, that's the focus of my professional work is service to that community. So we've put in various comments in the rulemaking process, which, as you know, Oregon has a 2-year period for the development of rules from the Oregon Health Authority. That process is well underway, and rules will issue about all kinds of things: the training, the licensure, the examination of facilitators, the citing and regulation of the service centers, et cetera, the development of the product. So all
Yeah.
of these rulemaking um, considerations are currently underway, and the rule advisory committees are doing their work to help in that rulemaking process. So various of those rule advisory committees are busily at work, and more to come in the future. And then the rules will issue not too far out from now because, we are well into the second year of the 2-year period. And so, yes, I'm quite involved and engaged with, and of course, at my office, Dave Kopelak and some of our associates worked on the drafting of the measure. So, really, no one in the state of Oregon knows more about the measure than Dave. So we're already fielding many, many client inquiries about how to cite a center for facilitation service. And those take some time because, of course, there are a lot of land use considerations that will be coming up for those who are interested in the creation of a facility. And so there's a long lead time. So for those in your audience who are interested in creating businesses in Oregon operating pursuant to that act, now is the time really to be speaking with your counsel. And certainly we invite people to contact us at Emerge for advice on that if they need help with getting their business plans and intentions pulled together so they can be ready to hit the ground running less than a year from now.
Mm, right. What does I know advisory group still has yet to submit final documents to the state with their recommendations. But as of right now, like, what does January 1 look like in Oregon?
Right. Well, we don't really know. The beauty of this 2-year ramp up is that there has been time for very deliberative process. And I think the people on the psilocybin advisory board have taken their task really seriously and devoted a lot of service to careful, deliberate thought about what does need to be in place. And so that process is what is unfolding now. And when process is really good, product is typically good. And my expectation is product will be very good here in terms of a regulated program that functions smoothly and serves the needs of those who could benefit.
Mm, beautiful. Yeah, it's a really interesting project, and I'm happy I was able to be as involved as I was, even though I live in Colorado.
Well,
Um,
it's coming to Colorado, as you
phew,
know, and
yeah,
we
let's talk
are,
about that in a minute.
yeah,
I'm kind of
yeah.
curious, like, since you were involved, what if you're up for it? What are some of your favorite things about this measure and how it's being enacted, and maybe a couple things about what's your least favorite about it?
As you know from this interview, I see everything through the lens of how will this meet the needs of patients with advanced illness. And so the good news about the Oregon measure is that it is intended to be able to serve that population. I will say one of the things that I think was an oversight in the drafting that has now been corrected in some of the states that are considering next generation measures modeled after Oregon's is, as you know, the Oregon measure restricts administration sessions to a service center. For patients with advanced illness who are receiving all of their health care, medical care, therapeutic care at home because their medical condition requires that, we need an accommodation to serve those patients in their home setting. And so, for example, in Washington state, I was involved with a measure that was under consideration there, and it had a special provision to address that. In the measure in Colorado, there is address of that. So I'm grateful and pleased to see these next generation measures noticing that oversight. That will need to be addressed in Oregon, either through a legislative tweak or a court can mandate a reasonable modification because, of course, it is not permissible for a state to create a program, benefit, or service that excludes people with physical disabilities. That is prohibited by disability rights laws.
Mm, right. One of the interesting things debated hotly in the space is, should facilitators have direct experience with the substance? I generally think yes, but there's going to be cases where people are disabled and sick and perhaps too sick to have an experience. And should we exclude them from this kind of work and employment? I think that's an open question. I don't have a real answer yet, but just further on your point there, absolutely.
Yeah.
um, yeah. So no, Colorado is really exciting. There's two measures. One is just simply decriminalizing all plant psychedelics. I told Carlos from Decrim Nature, I call his group Decriminalize Some Nature. Um, Last time I got the chance to meet him, and it's okay, but I'm more interested in a pathway to making it legal because there's so many people that don't speed, never want to break
Yeah.
the law, and in fact should have a safe legal container with a good safe supply if you're dealing with a really serious illness which
Yeah.
is life threatening or
Yes.
terminal.
Yes. Absolutely. I really appreciate your calling that out because decrim measures either reduce or attempt to eliminate state or municipal criminal exposure. They don't make it affirmatively legal. And the safe harbor of something being made affirmatively legal is desirable for a whole host of reasons. And ideally, there would be both state and federal safe harbor. So, of course, the elephant roaming the room in Oregon and in future elsewhere, if other states follow this legalization path, is what will the position of the federal government be when a state has legalized and created a regulatory framework for psilocybin services, for example? And that's an unanswered question. I have a law review article I'm working on right now that looks at exactly that. And of course, looking at the history of cannabis, where eventually, after many years, there was something of a federal safe harbor when the Department of Justice issued a memorandum that it would refrain from taking any enforcement action where states had made something legal. That kind of approach doesn't offer that much safe harbor because, of course, those memos and those policy positions can change when the office holder changes. So I'd like to set the bar higher and hope for safer safe harbor. But this whole question of what safe harbor will emerge, if any, remains to be seen. But yeah, I mean, Colorado's interesting. I think they're coming to the place where very soon it'll be clear which measures will be going forward. I know there were an array of measures being looked at and sort of field poll tested. But I think very soon the decision will be made which measures will be going forward. The measure that would create a legal state program is really interesting because it's broader than Oregon's. As you know, it addresses many more psychedelic substances. So that's a bigger lift than was the case in Oregon. Um, so it's an exciting time, yet to be seen whether that broad of a measure can gain traction and pass.
Right. Right. And I think it's going to require both sides coming together and attacking this, hitting the streets for votes and signatures, etc. ASAP. I know
Yeah,
they're still trying to work it out.
yeah,
Um, do you? So I don't know how to think about this problem yet, but in my opinion, a lot of harm comes from prohibition and a lack of safe access and safe supply, right? Um, Decriminalized nature theoretically is trying to address that with a lot of their decrim bills, theoretically, but they don't talk about how they're going to reduce fentanyl ODs at all, right? It's not really part of the talk track. Um, and even in the legal bill in Colorado, it's not really talked about either because it's more of a psychedelic therapy services type thing than how do we keep our people safe and stop harming them. Um, so one of the decrim nature arguments, and I'm sorry that my preface there is totally irrelevant, I believe. Anyway, their argument often is that they don't want to see legalization before decriminalization because they believe the drug war will still have a substantial amount of power, and that all of these services will only be available to moneyed people, people of privilege. And I have some arguments against that. I understand their point a little bit. And, if legalization happens, money will then start flowing into movements to keep these things with criminal penalties. But I don't know. Do you have any kind of perspective that you wouldn't mind sharing around that kind of talk track?
yeah. I mean, it's not an area of specialty of mine per se, but
Hmm.
what I can reflect on from my work around death with dignity is before there was a legal option, there was a widespread underground practice. And what
Yes.
happened in the underground was very scary. It is where the Dr. Kevorkians of the world ruled, and access was random, and the quality of the provider was very random. And no patient dying of a terminal illness wants to go into the back alley. They much rather go into the office of the reputable, respected professional that they know and trust and receive service there. So I do think there's an analogy here because, of course, it's known that there's an underground practice. And again, there has been some pulling back of the curtain on what happens in the underground. And not everyone follows what would be considered best practice guidelines for how the client is treated. And there have been some scandalous reports, and that's scary for people, and particularly people who are vulnerable and fragile, as patients dealing with advanced illness are. And so I think bringing this out of the back alley and into the light of day, where reasonable regulation and ethical principles can govern practice, is really good and really important.
Mm. Yeah, I generally like that. I can see a lot of scenarios in which regulators would make bad laws. We ended up with the DEA, for instance. And yeah, so I like your hopefulness. I get, and I appreciate it when attorneys with tons of experience aren't as cynical as me with much less experience. It's just like it's a real challenge
Yeah.
to want to trust these people when.
Yeah. Well, and I can't resist. You've made me flash on the really interesting story called "We Will Call It Paula," which is up on the website of the North Star Pledge. And I'm imagining that many of your listeners know about the North Star Pledge. For those of your listeners who are attorneys and who are interested in being members of the Psychedelic Bar Association, of which I'm a co-founder, we have made it kind of a cornerstone of the Psychedelic Bar Association that those who want to participate in this professional association know about and embrace these principles, which attempt to hold practice to a higher ethical standard and to embed into practice recognition for the history and tradition and practices around psychedelic substances, which are very rich and ancient. And, and so, one of the documents on their website is this quite dystopian story called "We Will Call It Paula," about what happens when commercial interests kind of run headlong into creating psychedelic businesses. And it's a cautionary tale.
Mm. Well, thanks for pointing that out. Yeah, I think I was with somebody you're affiliated with in a webinar the other day, and they brought it up too,
Good,
and that it's part of this bar association. I
good.
find that interesting. Um, yeah, I didn't agree with all of her arguments, but I'm glad she was able to share.
Yeah,
Yeah, and it's an interesting thing. How do we do this well? We're in a new phase. These are substantially different substances from most other things we've dealt with from a regulatory point of view, right? Like even make business out of them, right? It's very different.
yes. Well, and we've already had the opportunity to witness very different behaviors adopted by some of the players. And I mentioned earlier USONA Institute and it's putting its synthesis process in the public domain, which is a generous sharing, which I think many people want to see nurtured in the psychedelic world. And yet, we've also seen the Compass approach, which has been to attempt to patent virtually everything, including whether you wear eye shades or hear music in an administration session. So these are really different ways of proceeding. And which is it going to be, I think, is a question that is hanging large over all of us.
Right. does their I don't know if you saw the leaked memo a while ago about a de facto monopoly based on IP at one of these large organizations. I don't want to name them on this episode, but I've named
Yeah,
enough. But
I
it's,
think I know
scary,
to what
right?
you allude. Yes, it is. It's so out of keeping with what these substances are here to teach us,
Hmm.
that that sharpness of that contrast is deeply unsettling.
Right. And when I'm trying to give people hope, I say, well, they can't really make the drugs that much more illegal, guys.
Right,
Regardless of what kind of IP scenario we bump into, we're
right.
probably going to survive here,
Yeah,
and it's going to work out. It is frustrating, um, but it's like uh, I don't know, Tide trying to patent all dish detergent or something. It's
right,
like it's not going to happen, guys. Like, nice try. It's going to
right.
bankrupt everybody with all these lawsuits. But Kathryn, we're about an hour, and I really appreciate your time and your perspective here. Is there anything you'd like to leave us with?
I'm really grateful for the opportunity to come on. We talked a lot about the right to try advocacy. That kind of advocacy costs money. And if it's of interest to any in your audience to be part of the philanthropic community that's supporting that work, we'd be super grateful. Hundreds and hundreds and hundreds of attorney hours have gone into the developing and the crafting of the arguments that have been put forward and that continue to be put forward. And also, all of this work to bring attention to the behavior of the DEA through outreach to federal elected officials and discussions with media. That all takes a lot of time. And we do have a fund at a nonprofit. The NOAC Society in Boulder is the fiscal sponsor for the RTT Advocacy Fund. And no donation is too large or too small. So I'd love to give you a link for the site that shows how to make those contributions. And if anyone thinks that work is worthwhile, that's an opportunity to support it.
Beautiful. Yeah, please do keep us posted. We have a pretty engaged listenership here, and I would love to support your efforts. Been a fan for a long time now, Kathryn. So it's been
Well, thanks
beautiful
so
having you on
much.
the
I'm
show.
super grateful. Really enjoyed it. Look forward to hearing this air.